So good afternoon, everyone. Let's get started. My name is Jim Baillie, and I'll be the moderator for our program this afternoon, which we're calling How to Save Your Business in the Midst of an Unfolding Crisis. So no one on this audience needs to be told that we have a crisis, two crises really. One is a health crisis for the COVID-19 virus, and the other is a business crisis with so many of our businesses closed or having much reduced business. We don't know how this is going to turn out or how long it will take. We don't know how long the virus will last. We don't know how long we'll be in some form of shutdown, but we do know that a lot of businesses are suffering now and that they will suffer. They may not be able to reopen at all, or if they're able to reopen, they may shortly fail. So the purpose of this seminar is to give some assistance to business owners and to those who advise businesses so that their chances of coming out of this will be much improved and their business can be saved and perhaps even thrived. The webinar is presented by our law firm, Fredrikson and Byron, which is headquartered in Minneapolis and has offices in Mankato, Des Moines, Fargo, Bismarck, Mexico, and China. The presenters are from our banking and finance group and from our bankruptcy, restructuring, and workouts group. To save time, I won't be introducing them with an extensive bio, but you can look them up. Their links are available in the invitation that you got to this program, and their addresses are shown in our final slide. But we encourage you to reach out to them or to any of us individually with your own questions. During this program, if you have questions, feel free to type them into the chat box, and to the extent that we have time, we'll address them at the end of the program. So just open the chat feature and type your question. Our program has been approved for CLE credit in Iowa, and it's pending in Minnesota. So let's turn to the next slide. So this is a summary of our presentation today in 6 parts. The first will be financial resources available to borrowers, to businesses, and that'll be covered by Levi Smith and Erin Byom. The next part has to do with planning and process, and that'll be covered by Ryan Murphy. Ryan will also talk about working with lenders, what's happening on the ground now and what may happen in the future. The following part will be dealing with landlords, and that'll be covered by Steve Kinsella. And we'll deal also with vendors and suppliers, and Sam Andre will talk about that. And finally, I'll talk for a few minutes about the Business Reorganization Act. So with that, let's go to the next slide, and Levi Smith and Erin Byom, take it away.
Thanks so much, Jim. This is Levi Smith. I'm an associate in our bank and finance group here at Fredrikson. And today I'm going to talk with my colleague Erin Byom about some state and federal financial resource programs that are available to companies to make it through this difficult time. I'm going to focus on 2 federal programs that were established under the CARES Act that passed a little over a month ago, starting with the Paycheck Protection Program, and then also touching on the Main Street Lending Program. I'm going to start off with the Paycheck Protection Program, and as I'm sure you all know, this program has been of much interest in the news, and there's been a lot of discussion about how it's going, including the fact that the funds were originally exhausted, but have now been increased and applications are back open now. One thing, after working on these loans for about a month now, I will say that the devil is in the details, and it's a complicated program with a lot of different fact patterns that may be applicable to a particular company. So I'm going to give a high-level overview with a focus on what the proceeds from the program can be used for, and then touch a little bit on the forgiveness aspect as well, because that's also very important. But it'll be fairly high level. Happy to discuss any particular questions or situations at a later time or in the questions if there are times for it. So on the Paycheck Protection Program, just as a general overview, that is a program that's funded by the federal government through the Small Business Administration with forgivable loans or potentially forgivable loans that are funded through existing banks, farm credit banks, community lenders, and other approved lenders for this program. The loans are up to a maximum of $10 million, but they're subject to a formula for determining the actual loan amount. And that formula is based on taking 2.5 times a company's average payroll cost, average monthly payroll cost, and that gives the actual maximum amount of the loan that the company is eligible for. Just a couple of about the terms of the loan. If it's not forgiven, it's at 1% interest rate, and it has a 2-year maturity from the date of disbursement. So decently favorable terms, even if the forgiveness aspect doesn't apply. Companies, there are some restrictions on which companies are eligible for these funds. Generally speaking, they are companies with 500 or fewer employees. There are some exceptions to that as set forth in the CARES Act. And one thing of note, as you may have read in some of the news about this, the affiliation rules do apply, which basically means if a company is controlled by or under common control with another entity, it's possible that those two entities will essentially be deemed as affiliates, and their employees will be counted together for purposes of determining whether they are under the 500 employee limit. There is an interesting exception to the 500 employee limit rule, which is this alternative size standard that was provided by SBA. And a company can meet this alternative size standard even if it has greater than 500 employees if it meets 2 tests. And the tests are that both the maximum tangible net worth of the business is not more than 15 million, and the average net income after taxes for the past 2 full fiscal years is not more than 5 million. So there are a couple of companies, there are companies out there who may meet this alternative size standard, and it's potentially something to look at if you or a company you're advising are above the 500 employee limit. I'm going to move on into what the funds can be used for. There are essentially 4 categories of uses for the funds. The main category are for payroll costs, and payroll costs include things such as salary, wages, and other cash compensation, certain leave benefits, including vacation, family, sick, and medical leave, the provision of group health care insurance, a fairly broad reference to retirement benefits. It's not entirely clear what all that encompasses, but that is deemed to be part of payroll costs. And then also state and local taxes based on the compensation of employees. In addition to payroll costs, other permitted uses of the funds are for rent, utilities, and interest on mortgage obligations. One thing I did want to note is that for payroll costs, the cash compensation for a particular employee is capped at the equivalent of an annualized $100,000 annual salary. So if you have an employee who makes greater than $100,000, you're essentially limited with the amount of the funds that you can use to pay that employee's payroll. Next, I'm going to move on to the forgiveness aspect of it. So this is one of the really important and nice features of these loans, is that if certain conditions are met, the loan will be forgiven and will essentially be turned into a grant, and the borrower won't have to repay that amount to the lender. Essentially, the Small Business Administration will make the lender whole for that amount, and it'll be forgiven. An important rule for the forgiveness aspect is that if you remember back to those 4 uses I talked about, the payroll cost, the rent, utilities, and interest on mortgage obligations, at least 75% of the loan proceeds need to be used for payroll costs in order to qualify for forgiveness. So the federal government decided that the purpose statement of this program is to make sure that employees are continuing to earn paychecks, and they want to sort of force at least 75% of the loan amount to be used for covering paycheck and payroll expenses in order for the borrower to qualify for forgiveness. Forgiveness is going to be an important topic, and unfortunately, we're still waiting for additional guidance from SBA on what exactly the forgiveness process and forgiveness documentation looks like. That hasn't come out yet. We expect it hopefully any day here. So we've been advising clients and others to make sure that you keep really good records about what the loan proceeds are used for, so you can trace those proceeds and show that they were used for a permitted use, especially with respect to the payroll cost. I think it may be advantageous to deposit the proceeds from the Paycheck protection loans into a separate bank account, if that's possible for the business to be able to really track where those funds are coming into and where they're going out, and to be able to validate those with payroll records and other things like that. So I think there's going to be more to come on the forgiveness aspect, and that's obviously going to be a very important component here in the next couple of months. One important point that I do want to mention about forgiveness is that for purposes of calculating that 75% and how much was used on payroll expenses, there's an 8-week time period that begins from the date that the loans are dispersed, and it'll be beginning on that date for the next 8 weeks will be the time period over which SBA and the lender are going to look to see how much of those funds a business used for purposes of calculating forgiveness. And I'll quickly mention two instances that could impact the amount of the loan that is forgiven, and that is if a company has reduced employee headcount or reduced employee salaries during this time period from essentially, I believe it's February 15th until June 30th. If they take certain actions, that can have an impact of reducing the amount of forgiveness on sort of a dollar per dollar basis. There's a formula in the Act that is a little bit complicated, but do note that if there have been headcount reductions or payroll reductions, those can lead to a reduction in forgiveness. The final point I want to say on the Paycheck Protection Program is that under the CARES Act, there were certain other tax benefits related to deferral of payroll taxes and other things along those lines. You have to be careful because if you take advantage of the Paycheck Protection Program loans, it's possible that you'll be ineligible for some of those tax benefits. And depending on the particular company, the tax benefits may end up being more beneficial. So just something to check with your tax professional on there. Moving on into the Main Street Lending Program. So this is a new program that was rolled out under the CARES Act. We don't have a ton of information about it yet, but essentially it's supposed to be available for small and mid-sized businesses. And the real purpose of it is to allow banks to increase existing or provide new credit facilities to borrowers. And then the Federal Reserve is essentially going to buy a 95% participation interest in the new or expanded credit facility, thereby taking that risk of non-payment off of the bank's balance sheet, and essentially 5% of that loan amount will remain with the bank. So I'm just going to run through a couple of details on this program. We don't have the official rule or the official program implementation guidance for this program yet, but we do have some information. Eligible borrowers for this program are businesses with up to 10,000 employees or up to $2.5 billion in 2019 annual revenue. And it must be a business that is created or organized in the United States with a majority of its employees in the United States. Let's see, this program would be a 4-year maturity. It would amortize over that 4 years. However, the principal and interest payments are deferred for the first year. The interest rate is adjustable. It's based on the secured overnight financing rate plus 250 to 400 basis points. The minimum loan size is $1 million, and the maximum size depends. It's a formula. It's essentially depending on if it's a new loan facility or an expanded loan facility, up to $25 million for new or up to $150 million for expanded. And like I said, there's a formula that may result in that being a lower amount. I talked about how the Federal Reserve will essentially buy 95% participation interest to share the risk with the lender. There are certain fees associated with this, so a borrower would have to consider whether it makes sense in light of the closing fees and the annual servicing fees, if it made sense financially to do this. There are just a couple of covenants that I wanted to touch on, especially for the borrower. If the borrower participated in this program, they would not be able to use the proceeds of these loans to prepay other debt. And while the loan is outstanding, they must refrain from prepaying other debt of equal or lower priority, except they can make mandatory principal payments. They have to show that there's a need for this financing due to the COVID-19 pandemic. They have to use reasonable efforts to maintain employees and payroll. They have to meet in certain leverage ratios, so they don't get above a certain leverage ratio based on their EBITDA. They must agree, if they're publicly traded, to not engage in stock buybacks or certain dividends for a certain period of time. And finally, there are compensation limits imposed on certain executive officers that a company must consider as well. So that's, again, a very high-level overview of the Main Street Lending Program. There will be more to come on that as it gets rolled out by the Fed, but that should provide a brief overview of at least another option for especially larger businesses out there facing these times. With that, I'm going to pass it over to my colleague, Erin Byom, to talk about some additional financial resources.
Thanks, Levi. The first one I'm going to talk about is another loan program offered through the SBA, which is the SBA Economic Injury Disaster Loans, or EIDL loans. And these are now available to all U.S. states and territories and available to small businesses, private nonprofits, small agriculture cooperatives, and small aquaculture enterprises impacted by COVID-19 since January 31st, 2020. Now, with the additional funding that was recently provided by the new COVID-19 relief package, the SBA is going to begin processing EIDL loans and advance applications that are already in their queue on a first-come, first-served basis. And the SBA has noted that further information on the availability of the EIDL portal to receive new applications will be provided as soon as possible. So that, from what the SBA has issued, it's our understanding that the EIDL loan portal is not yet open for new applications, but they are processing ones that are currently in the queue. The loan proceeds received from an EIDL loan may be used to pay fixed debt, payroll, accounts payable, and other bills, and the maximum loan amount is $2 million. Under the CARES Act, though, an EIDL loan advance of up to $10,000 is possible, so a borrower may apply for that $10,000 advance. The advance is forgivable if it's used for permitted purposes. If the borrower receives a PPP loan, the advance is subtracted from the forgiveness amount. However, the EIDL loan itself is not forgivable. So a borrower who received an SBA EIDL loan from January 31st, 2020 through April 3rd, 2020 can still apply for a PPP loan. Borrowers who use the proceeds of that EIDL loan to cover payroll costs can still apply for that PPP loan, but they must refinance the EIDL loan with the PPP loan proceeds. And proceeds from any advance of up to the $10,000 on the EIDL loan will be deducted from the loan forgiveness amount on the PPP loan, and that's important to keep in mind if you're thinking about applying for both of these loans for your business. Again, it's important to note that the EIDL loan itself is not forgivable. For businesses, there's an interest rate of 3.75%, and for nonprofits, the interest rate on these loans is 2.75%. The term for these EIDL loans are up to 30 years, and the loan payments are deferred for 1 year. The application process, again, it sounds like the portal is not currently up and running to receive new applications, but you need a number of forms that you have to submit when you apply online directly through the SBA. It's important to note that you can do this yourself. You don't have to go through a lender when applying for an EIDL loan. You can fill out the form directly through the SBA. Some of the forms that you need are a business loan application that's completed and signed by the borrower, an IRS form 4506T that's also completed and signed, complete copies that include schedules of the most recent federal income tax return for the business, and if one is not currently available, an explanation is required. A personal financial statement and a schedule of liabilities listing all fixed debts. There's also additional other documentation that you may need to provide, but work with your SBA case manager for assistance to make sure that you've got all the right paperwork in order to get your application processed the quickest. And the deadline for these loans, the application is open until December 21st, 2020, although that is dependent on funding that may be available because funding is going quite quickly. The next loan that I want to talk about, and that's specific to Minnesota, is the Minnesota Deed Small Business Emergency Loan Program. Now, these are available to qualifying businesses under Governor Walz's Executive Order 2015. So this is restaurants, bars, salons, other cosmetology places, anything that was listed under that executive order, those are the businesses that are eligible for this type of loan. These loans must not be used to provide a loan to a related business or to refinance debt that existed at the time of the COVID-19 peacetime emergency declaration. So while the Minnesota Deed website doesn't list specific uses for this loan, it does have explicit impermissible uses for this loan. So it's important to pay attention to that and be careful for that. The applicants may receive anywhere from $2,500 to $35,000, depending on what the commissioner determines is the applicant's need. And up to 50% of that loan is possible for forgiveness if the deed commissioner approves it and the business remains operating in the community at substantially the same levels for 2 years following loan disbursement. So that forgiveness is a little bit subjective there. So it's important to pay attention to that when applying for this type of loan. The term is to be paid back monthly over 5 years. And it's important to note that with this loan also, it must be repaid if financing is received subsequent to loan approval. So it won't be forgiven if you receive additional funding, you've got to pay that back. This can be applied for online at the MND's website, and they have a list of certified lenders that you must go through when applying for the loan. And you should use a lender that's in the county where your business operates. This loan is also interest-free, but as of right now, it's currently exceeded funding and is not available. We're waiting on the Minnesota legislature to see if they will provide additional funding, and Deed has told applicants to continue checking the website pretty consistently to see if funding has become available. Right now, it currently is not. And with that, I will hand it back over to Jim.
Well, thank you, Levi and Erin. We're going to turn to Ryan Murphy now to talk about planning. What planning should the business be doing now in anticipation of reopening? We know the cash is king. So my question to you, Ryan, is how and when should that cash be deployed? And second, what kind of advisor help should a business engage?
Thanks, Jim. I think there's really two phases to that first question about use of cash, and that is one, kind of the near term here at the stay-at-home period, and then two, once operations are restarted, albeit may not be in the normal environment as we saw, say, 6 months or so ago. And so with that, I'll be talking about each of these separately, given that the goals are different. There's a different environment, and the relationships with creditors and other constituents is also different. Relative to the second question about working with counsel or advisors, really think about this in three ways. One, consult. Two, communicate. And three, as it relates to commencing any action. The first is in terms of consulting, where you need help putting together the plan, understanding the basics relative to legal rights and remedies, both on the company or borrower side, as well as creditors or other constituents. Second is in terms of communicating that plan, and that may be best done by the company itself or its existing advisors or employees, but it also may be that it's best in certain environments for that to be done by counsel or financial advisor. And then the third piece is in terms of any action commenced or any remedy is sought against the company itself or the borrower or owners, or in the event that the company needs to seek some kind of protection, bankruptcy protection, then obviously advice will be needed and representation needed there. Each situation is obviously going to be different, but we encourage people to consult with their trusted advisors, early on. And ounce of prevention here is worth, a pound of cure. Where it is very difficult is where the reserves or whatever capital was available is basically been exhausted, and then they look to an advisor. And at that point in time, you're really out of options. And so to best understand the environment and what options are available and to maximize those options, we encourage people to initiate those consultations right away. In terms of the kind of the near-term business plan and cash flow projections, it really starts with maximizing, the cash and cash receipts, the inflows, and that really in this environment is really preserving cash itself and maximizing liquidity. So we're encouraging clients in most instances to draw down on any lines of credit. You're seeing that happen across, many companies, and in particular, a number of industries directly affected by this. It's almost been uniform in terms of that kind of approach. And again, these are the types of actions that companies should be undertaking right now as we are in this near-term environment. Exercising those rights on lines of credit while there's fees and there's some interest, it really is buying yourself an insurance policy here, given the environment. We're seeing our sharp private equity clients and others, exercising these rights, and even down to clients that may own multiple bars or restaurants, exercising those again for that insurance policy. It's also, I think, important to identify any assets that are not pledged to existing lenders, to identify any other non-critical assets that they may be a source of liquidity here in difficult times. It's obviously difficult to sell any assets or any part of the business or divisions right now, and so that's not likely a viable solution. But just understanding those circumstances and what alternatives may be available are key. Moving to the other side really of the ledger, then focusing on the outflows, really limiting those expenditures to payment of absolutely critical expenditures. We'll talk specifically later about those relationships, specifically as relates to lenders, landlords, and trades and what's happening on the ground. But ideally, from a high level, you're communicating to the important creditor constituents here, and you're getting some agreement or understanding about what the approach is going to be. And obviously, there's an interrelationship to all of this as we see this as supply chains are affected, both big and small here, but also with the understanding that your liability is an asset of another business, and that communication and that understanding can be key to providing that flexibility, both in the short term and the long term, as relates to what your needs will be. And at this point in time, it's difficult, if not possible, to promise what performance can be. So what we encourage people to do is really to promise about what they will follow up with, what information they may follow up with. And that may simply be just another touch point with the creditor constituent where you don't have any particular promise to perform, but simply communicating that you identify the issue, you're working to solve it as best you can in this kind of environment, builds that relationship, strengthens that relationship with the creditor constituents. That is very important here as we move forward. Understanding these rights and defenses and remedies in this current environment is critical here. In the near term right now, those defenses, whether they be just simply practical or otherwise, are really stronger than typical. There's been a number of laws and executive orders that have been entered staying foreclosures. Many of those are focused on residential foreclosures, but many in many states, including Wisconsin, Nevada, and others, are focused on commercial foreclosures and other commercial remedies. There's also limited court availability. So even if you have the right to go into court, it's very difficult to effectuate that. Except in really emergency situations. I think also there's a reputational risk for creditors to initiate actions in this type of environment that will probably change as the weeks and months roll on, but I think that is the case right now. And with that, there's also just the practical limitations about limited bandwidth of creditors. Right now, banks are simply choking on the number of SBA, the PPP, and other kind of loan applications that are in process. In the last couple of weeks, they have processed more applications through the SBA programs than they've done in the last 15 years. And so just the demands associated with that is focusing attention in certain areas and drawing it from others. And finally, there's really just an uncertainty about the outcome of exercise of remedies right now. If a lender or another party has a right to foreclose or exercise those remedies, what that'll mean on the ground in terms of any type of collection or any type of sale in the future is very uncertain. And that uncertainty then, I think, again, buys additional time and leeway for companies, particularly where they're being proactive in addressing matters. So shifting to the second kind of phase of the plan, the long-term plan and process here, it is very difficult, maybe not if impossible right now, to project when the reopenings are going to begin, what that reopening will be. As a number of financial advisors who are in the business of preparing these financial projections day in and day out, even they are sort of attributing some of this to guesswork, but it's necessary guesswork that you have to go through because you educate yourself as part of the process. And with that, and to understand the uncertainties, what we're recommending clients do is really kind of a best case and a worst case sort of outcome here in terms of their projections to provide them some understanding about what that environment is. And as they model this out, to the extent that they can get any information from association kind of data. So a business we're working with is in the entertainment business in Tennessee, and there is some local community information that is being made available about what the return may be. That's very helpful as it relates to putting together those projections or models. Certainly not going to provide absolute answers, but at least some data point to build off of. In addition, I think people need to look to other countries where that reopening is starting. Again, not that will be perfect answers, but to have some understanding about how these things are phased in and what the actual experiences of businesses are very helpful. In terms of specific expenses, it's obviously aligning those expenses with what that new revenue will be forecasted and making very difficult decisions there. As to existing accounts payable, the recommendation really is to freeze amounts that are sort of currently due now. Try to get as much vendor credit as you can, and to the extent you need to, what you're proposing to do is to pay for that existing or that new credit and sort of freeze that past due amount until you have enough certainty about what this reopen is that you can make some plan or put some plan together that you can then communicate to creditors about, here's what our ability to perform will be. It's going to be important to communicate that plan to creditors in a way that has the greatest credibility. And so the more certain you can be about timing and amounts, even if it isn't payment in full, and certainly not payment in full in the near term, the more credible, the more supported it is, the more understood it is, the much better. And again, I think that's where working with advisors can be key. And what creditors are really after as they assess this is to understand that, this financial plan that is underlying this plan to make a proposal to creditors has been tested, has been put through the paces. And with that, there's no money that has been sort of hidden in the mattresses, or others that are insiders aren't taking advantage of the situation. So who you're working with as a financial advisor and legal advisor can be key to then getting that buy-in to a plan that hopefully creditors will accept. As you look then to what that kind of long-term process is, there is going to need to be an assessment about in this new environment, is continued operation, or is there a viable business here? Unfortunately, there will be a number of businesses that will not either have the capital to restart, or simply won't have the capital continue. In those environments, unfortunately, there'll have to be a conclusion brought to that, whether it's through some kind of sale or wind down, and to make the best that can be in those types of situations. But there will be many businesses that should be able to survive. That is, they have sufficient operations, sufficient cash flow to meet those current expenditures, but are left with this debt overhang from past due amounts that may be due for a quarter or more. That is where understanding, I think, the rights that are available to businesses, whether in or out of bankruptcy, is key. That there is an ability, in particular through the bankruptcy process, to impose a plan on creditors that does pay them even less than the full amount. Now, there's a lot that comes with the ability to do that. And again, ideally, in almost every situation, you would rather institute that kind of plan out of court. But understanding what is available through the bankruptcy process can then set the baseline against which you can prepare that plan and communicate it to creditors. And then there's also the safety net for if you do not get enough or sufficient acceptance on that plan to then seek to institute it through a Chapter 11 process. Jim specifically will talk more about the Small Business Reorganization Act here at the end. But just simply note here that it has significantly turned the balance of power to owners or companies where their businesses have less than $7.5 million in debts, and have solved a number of issues that have really made Chapter 11 almost unavailable to those small businesses. And so there is a much greater use here and chance of success, particularly for reorganizations. So turning to relationships specifically with lenders here on the next slide, the lender relationship is probably the most critical relationship that any company has, particularly in this environment. And with that, your first engagement typically with the lender about, one, what the problem may be, two, the timing, and then three, what the solution may be, are typically had with the lender, and realizing some kind of agreement or tacit consent on those issues is important or critical as you move forward. With that, it's helpful to understand, I think, where lenders are coming at these issues right now, and that really starts first with a federal and state interagency statement that was issued, frankly, a number of weeks back. It encouraged financial institutions to work with borrowers affected by COVID-19, short-term modifications of loans, in particular over kind of a 6-month period of time, and it did so without requiring those lenders to treat the loan as a troubled credit. Where a loan is booked as a troubled credit or identified as a troubled credit by bank, then the bank has to reserve capital on account of those loans. In this kind of environment where banks are funding a great deal of loans, that's a significant hindrance for them as they think about their own operations and how they're running their bank. The other, I think, important consideration to understand is the various programs out there for payment of loans that are backed by the government, or payment holidays for loans that are backed by the government, or simply those payment holidays that lenders themselves are sort of instituting. And in terms of specifically some programs where there are certain government-backed loans that payments are being authorized. One such example is the existing 7A loans through the SBA, where the SBA is in fact making payments over 6 months, and that's even occurring for a client of ours that's in a Chapter 11 case right now, where the SBA is making the payments over the next 6-month period of time. There are also a number of government-backed loans, whether it's the Federal Housing Administration or otherwise, where there are payment holidays for a specific period of times. And then a number of the lenders themselves are sort of setting up programs to deal with this just influx of demand as it relates to requests for forbearance or payment holidays. And so I think it's important to understand, what loan you have, do your research about that, and then also do your research about whom the lender is. A number of them, in particular, the larger lenders, have specific programs or processes identified, say, on websites or otherwise, that identify how to work through these issues. So what does that really mean in terms of what's happening here on the ground? I would say in the near term, there has been a great deal of accommodation, and an accommodation that we have probably never seen before, particularly on this kind of mass scale. Long term, there really has been no action, I think, taken by banks themselves to try to address these things as we look out, say, a year or more, and obviously due to the uncertainty both from the borrower and the company and the lender itself. What does that mean then in terms of what's happening? What you're seeing are, affirmative covenant waivers or affirmative statements that they'll not declare default. A prime example of that is in many loan documents, maybe all, there are bars to incurring other indebtedness. Technically, the PPP loans certainly are loans and other indebtedness right now. Lenders themselves are reacting to borrowers calling and saying, hey, can I get a waiver of this? Basically by telling them, don't even bother with this with me. That's not going to be an issue. Move it forward. And so the more you can clean that up, the more you can document that, the better. But I think it just goes to show the bank's temperature as it relates to these type of covenant defaults. The other piece, I think, as you look at financial covenants, whether they be ratios, tangible net worth, those things may be adjudged on a year end, so they may not be here yet. But as the weeks and months here move on, those may become increasingly relevant and increasingly important to try to get ahead of those issues. We're seeing many banks reduce payments over a 3 to 6 month period of time, such as the interest only. And under limited circumstances, we're hearing that there is moratorium on payments for 3 to 6 months period of time. I think most lenders are trying to steer towards sort of the 3 month period of time, sort of to that next quarter. Some are willing to go longer, and even hearing in some instances where some lenders, and I think this is probably the exception to the rule as we hear about the anecdotal evidence, is payment moratoriums or interest only for up to 9 months. Some banks, rather than modifying existing loan payments, are issuing new loans to allow for continued payments on existing loans. Obviously, this is less favorable to the borrower or the company, but is another tool that at least some lenders are utilizing that we thought would be notable. And then also lenders are waiving late fees and penalties, and that's specifically authorized under the interagency statement, or in some instances adding it to the loan balance. So I think the takeaway really from the lender relationship is to ask, to communicate why you are being directly affected, and to get agreement where you can, and even where you do not have agreement, to assess whether or not you simply should and defer making any payments here in the interim as we bridge to what may be a new reality in the weeks and months ahead.
Okay, thanks, Ryan. Next, we're going to turn to Steve Kinsella, who's going to talk about the other important relationship, which is landlords. So, Steve, what are the challenges for landlords and tenants today, and how are they being resolved?
Thanks, Jim. So right now, the lay of the land is similar to what Ryan had said about some of the lenders. I think he might have also mentioned it as to landlords. So there's executive orders for almost every state that either completely prevent or in some way limit eviction actions. The majority of states have more stringent limitations as to residential evictions, but even that, many of those orders actually apply to commercial tenants as well. And then you also have right now just the practical effect that a lot of courts are closed or have limited access and are very much focused on emergency situations, which evictions just are not considered emergency right now. And I also don't know if I'd want to be a lawyer attempting to evict anybody during this current crisis at this time. So really what's happening is that landlords are handling everything, including lease defaults, on truly a case-by-case basis. And it really should come as no surprise that it comes down to leverage. So what we're seeing is that tenants that have a lot of leverage, and tenants having leverage, think unique rental space, like large-scale restaurants that have a specific format. Kind of the common example I think we maybe have all heard about is that Cheesecake Factory. It'd be really hard for the landlord to try to evict or try to find a replacement tenant for a space like that. And then similarly, the anchor tenants, especially in a lot of these strip malls that have other lease obligations as to the smaller stores that require there to be some type of anchor store. So tenants that have leverage have really used that leverage, at least in the beginning now. So they've told landlords, we're just not going to pay rent for the next few months while we try to sort this out. Now, eventually that likely comes to a head, but because of that leverage position, the tenants have had a lot more say, and the landlords, at least for right now, have been willing to go along with that. Now, when the tenant doesn't have as much leverage, or even in the circumstances in which the tenants do have leverage, we're still seeing landlords move to apply security deposits. So obviously, almost every single lease has a security deposit. And what landlords have done is take those security deposits and apply it to the current month's rent. Some of the landlords that I've consulted with have been really concerned that some of their tenants are looking at a potential bankruptcy filing and have asked if there's any threat to taking the security deposit as a potential preference action. And what we've been advising them is, number one, you should apply it right away. It's always better to have the cash. And then also applying it now starts that 90-day clock ticking for a preference period. And then also, because you're applying it to this month's rent and presumably the tenant is continuing to occupy the space, there's good case law that says that either that would be considered a prepayment of the rent, or there's an argument for subsequent new value. So we've been encouraging all of our landlord clients that are asking us about applying security deposits to apply the security deposit, to make it clear that it's being characterized as rent for the current month on a sort of go-forward basis, and that we feel pretty confident that that would give us a strong defense to any preference action if the tenant were to file for bankruptcy. In addition to applying the security deposit, landlords then have begun to engage in negotiations with tenants, and they sort of have gone really two different routes. One is more of a forbearance arrangement. In that arrangement, the landlords will agree to either reduce or not require rent payments, and usually then calculate how much would be owed, including interest, and then have some type of agreement whereby that unpaid rent gets repaid. And then in addition to that forbearance on collection of the unpaid rent, we've seen landlords who have a higher leverage position have required, the normal sort of personal guarantees or a higher interest rate or other terms that they can get in order to agree to forbear on collecting that rent. I've seen a couple tenant clients that have engaged in a more creative solution that I actually think makes a lot of sense because it's a more holistic approach. So what these tenants have done is have gone to the landlord and said, look, we understand you have a mortgage to pay. So let's get your lender on the line and let's all three of us talk through a solution to try to get through the next 6 months. And so for the two cases that I've assisted with, they've been able to work out a deal where the lender has agreed to take a portion of principal or just in another case, interest only, and then they've set the rent for that. So that the idea is the landlord really isn't out of pocket, that the lender has agreed to reduce how much it needs to be paid on the mortgage, and then the tenant is covering that reduced amount through its rent. And so I think that there are some creative solutions out there through the forbearance arrangement that allows a tenant to continue to occupy the space and pay either reduced or no rent, but still allows the landlord to be able to recover something and be able to pay its obligations, because it's that constant relationship that Ryan mentioned, that every single constituent that you have, while you might owe a debt to them, they likely owe a debt to somebody else. The other version of negotiations we've been seeing is that there is just an extension of the lease. So there is some agreement right now whereby the tenant pays reduced rent or no rent, and then additional months are added on to the end of the lease. essentially at usually higher rent terms or consistent with sort of the final year of rent. Now, that is probably preferable from a tenant side because you don't have this forbearance issue, you don't have this unpaid rent issue, and then presumably a tenant is happier with a few additional months added to the end of the lease and not requiring to renegotiate a lease. And so that we've seen more landlords be interested in the forbearance route than necessarily negotiating an extension or some type of abatement on the lease, but we have seen some landlords doing that. Now, the final piece is that some landlords are taking this current situation as an opportunity to actually get out of some bad leases by terminating the lease. And a lot of that is targeted to landlords that really think their tenants are going to have to file for bankruptcy. So if a tenant files for bankruptcy and it's a reorganization or at least a Chapter 11 or even a Chapter 7 in which the possibility of the lease being assumed and assigned to a different party is there, the landlord, if the terms aren't good terms for the landlord might consider terminating the lease prior to that bankruptcy filing. And so I've advised a couple of landlord clients now that are not happy with the lease terms that they negotiated and are taking this opportunity to terminate the lease. Now, they have the tenant as a holdover and they're not moving to evict the tenant, but it allows them to sort of reevaluate and either renegotiate with the tenant at a later date, or also ensures that if that tenant were to file for bankruptcy, that there isn't a lease then to assume or assign. Now, a couple other considerations that sort of stem off from that is that you could look at modifying the lease terms as a part of the negotiation between tenant and landlord. And so kind of the key characteristics that landlords have been looking for are some type of an addition of a relocation clause, or an elimination of a right of first refusal clause, or some type of expense caps and adjustment on those expense caps. And then, as I mentioned earlier, landlords are always happy to get additional personal guarantees and then feel more comfortable with those guarantees moving forward. And some landlords that have more of a leveraged position have pushed for not only personal guarantees, but to have those personal guarantees be secured by some type of other collateral held by the guarantor. Now, tenants that are actually in bankruptcy have had some success in actually asking the bankruptcy court to intervene and authorize deferring payments. So normally if a debtor doesn't pay rent, that would be grounds for relief from the automatic stay and for the landlord to move forward to evict and to terminate the lease. But the example that comes to mind off the top of my head here is that in the True Religion case, the debtors were successful in asking the bankruptcy court to defer rent payments for the next few months in order to get through this crisis, or at least get further along in this crisis, to be able to figure out how a reorganization would look. So really what we're seeing is it's hard to say that there's a current trend line, but it really is dependent upon who has the leverage in these lender and tenant negotiations. But both sides are talking, generally speaking, and everybody is trying to work out a deal to modify the lease or create a forbearance to allow these businesses to continue to operate. But at this stage, it's just too difficult to tell if those will be successful or if there's a current trend line that is developing.
Okay, thanks, Steve. So the next topic, Sam Andre is going to talk to us about vendors and suppliers. And Sam, I know we're getting a lot of questions about force majeure or acts of God as excuse for performance on a contract and what impact that has on the other party to the contract. So if you can touch on that, we'd appreciate it.
Yep, thank you, Jim. So with that, in reviewing kind of the relationships with vendors and suppliers, a business, as Ryan mentioned, should typically kind of go through those near-term and long-term tools and processes in order to kind of evaluate their situation and address kind of the issues that are facing their business. However, there are some COVID-19 specific considerations that are important to think about in relation to vendors and suppliers, in particular, whether or not the contracts with those vendors and suppliers include such provisions as force majeure, impossibility of performance, and other types of similar contract provisions. So with those provisions, specifically force majeure, what that covers is whether or not an act of God would be allowing a party to be excused from performance under their contract. Fredrikson and Byron has been and continues to look into how COVID-19 fits under such contract provisions, not only in Minnesota, but across the United States, and how that affects the debtor businesses' continuing obligations under the contract, whether their responsibilities would be excused to their vendors and suppliers based on these provisions. Specifically under Minnesota law, the effects of COVID-19 on contract obligations based on force majeure and impossibility provisions is unfortunately unclear and significantly depends on a debtor's obligations to its trade creditors. For example, Minnesota federal courts have previously found that where a force majeure clause is ambiguous as to whether an event is covered by the clause, they have found that that should be interpreted to cover the event and then thus excuse performance. However, the same courts have also found that government action, which may or may not include the state executive orders and emergency orders that are currently effective in Minnesota and elsewhere, that those would not, unforeseen events would not be covered and performance would thus not be excused by these force majeure provisions. A very interesting caveat with force majeure clauses as well is although they do excuse performance of a debtor business as to kind of their obligations to vendors and suppliers under their contracts, it cannot also be used to as a shield as well and a sword. So specifically, the U.S. District Court for the District of Minnesota has held that a force majeure provision does not necessarily operate to negate or limit a non-excused party's termination rights under an agreement. Instead, such provisions are to be used to excuse one's own obligation to perform. So for example, while a debtor business would be able to excuse their performance potentially through a force majeure clause, they cannot sue their vendor or supplier for exercising that party's rights under the contract, such as for terminating the contract or any other types of rights that they may have. So while these provisions are definitely present a potential leverage position for a debtor business, they also have limits to that ability, which should be taken into consideration when potentially asserting a force majeure right. As COVID-19 crisis continues, Fredrikson does expect that these issues surrounding force majeure and related provisions will continue and expand into the court system. And within a few years, there is very likely to be a new round of case law interpreting Minnesota and other states' laws and the extent of these provisions is reached. And we will continue to keep tabs on those developments and continue to update our clients and other parties with interest in that. But bottom line, these sorts of provisions do present an ability for debtor businesses to approach their vendors and suppliers to try and negotiate various forms of relief under their contracts, and should definitely be considered when contemplating the tried and true tools that Ryan mentioned previously. In addition to force majeure and other contract provisions, it is still important to communicate your inability to your trade creditors to pay them near term due to the national emergency, and continue to seek trade credit where possible. This sticks in line with being transparent with your vendors and suppliers, keeping an open dialogue and leaving the potential to work out any debt issues or defaults under your contracts before collection actions might be filed. And allowing the business to continue to operate. And where critical, businesses should still pay for current purchases, such as supplies that are necessary to continue operating, so that they may continue to operate and thus be able to try to make a profit and get out from under the potential issues that they're facing during this national crisis. Again, we would reiterate that businesses should still only make proposals to pay past amounts to trade creditors as part of a comprehensive plan instead of paying them piecemeal. In this way, to try to address all issues facing the business and not just specific vendors and suppliers unless absolutely necessary. Additionally, one tool to think about is even if the trade creditor sues because a business has defaulted or is unable to pay under a contract, actual collection will likely be delayed for months due to the shutdown of the courts within Minnesota and many other states for non-essential hearings. And the benefit of this is that it will leave a business time to negotiate or potentially catch up on payments if possible, with state business starting to slowly open up again. The bottom line through all of this is that no one-size-fits-all approach is available with these matters. Instead, a company should just make sure to keep tabs on its particular situation and use these tools in any combination in order to address the specific issues facing them. And with that, I'll turn it back over to you, Jim, to continue on with the presentation.
Okay, thank you, Sam. So I'm just going to take a couple of minutes to talk about the Small Business Reorganization Act, which, as we've mentioned, is a form of Chapter 11, but it's faster, simpler, and cheaper. It gives more rights to the company and to the owners than a normal Chapter 11 case. This form of small business reorganization is new as of February 2020 and originally had a $2.7 million debt limit. But the CARES Act increased that debt limit to $7.5 million for 1 year through March 27, 2021. Key points of the SABRA Act are that the debtors get to retain their equity. In other words, the company is not in play. In most Chapter 11 cases, there's a real risk to the owners that the company becomes in play and that they could lose the ownership. The key economic terms are that the owners will be devoting 3 to 5 years worth of disposable income to the payment of creditors. So it will use that for partial payment perhaps on the secured debt, partial payment perhaps on the unsecured debt, when they perform on the plan, they'll be excused from the rest of the obligation. There is no cram down provision, so that it isn't necessary to get the approval of any particular class of creditors or even of any of them, period. Key point is that there's no creditors committee, which can reduce the cost considerably. In addition, there's a new form of trustee, new to Chapter 11, not to take over the business, not to right herd, not to find fault, not to uncover bad past deeds primarily, but to facilitate the possibility of the Small Business Chapter 11 plan. So there's virtually no experience with this, but we're quite optimistic that for the small business that may fit, that this can be done at a considerably lower price than a normal Chapter 11. So with that, we do have a few questions. Levi, I don't know if you've looked at these already, but two of them I think go to you. One is, are the Main Street Lending Program funds already being dispersed to borrowers? And second, is there a cap in terms of the total amount allotted to that program?
Yeah, thanks, Jim, and thanks for the questions for the folks who sent those in. So I don't believe that the Main Street Lending Program funds are being dispersed currently. There isn't a lot of guidance out there from the Fed on what this program actually looks like. There are a couple of, they call them term sheets on the Fed's website, and they were soliciting feedback until I think about the 16th of April on those term sheets. So we're expecting at some point the Fed will come out with a rule or regulation that will set forth some of the details of that program. So at this point, I don't believe any funds are being dispersed. And then the second question was, is there a cap on the Main Street program, the allotted amount? And I think that question is getting to the overall allocation that Congress has provided. And I believe that's $600 billion at this point. But remember that the loan size here could potentially be up to, I believe it was 25 million. So that those funds could potentially go fairly quickly. And for the expanded loan program, they're up to 150 million. I think there were a couple of other questions kind of in my realm and Erin's realm that I thought I would just touch on now while we while I'm speaking. So one was, is there any further guidance regarding how to determine if a Paycheck protection loan is necessary? So I think what's driving this question is in the PPP loan application, there's a certification that the borrowers needed to make that said something along the lines of that the current economic uncertainty makes this loan request necessary to support the ongoing operations of the applicant. As you may have read in the news, there's been a lot of pushback, especially against some public companies taking these funds, even though they have, or at least what some folks view to be sufficient other access to capital. So there was an additional frequently asked question posted and answered by Treasury late last week. And the question, it's a little bit confusing about how, if it applies to everyone. The question was, do businesses owned by large companies with adequate sources of liquidity to support the business's ongoing operations qualify for a PPP loan? And the answer that Treasury gave to that question was, it depends. The borrowers must assess their economic need for the loan under this standard. It says that the borrower should carefully review their kind of needs in the documentation and the certification, and they must make this certification in good faith. They have to take into account their current business activity and their ability to access other sources of liquidity sufficient to support their ongoing operations in a manner that's not significantly detrimental to the business. Treasury gave an example that a public company with substantial market value and access to the capital markets probably would not be able to make this certification in good faith. So that's maybe on one end of the spectrum, a public company with substantial market value and access to capital markets. And then I think it gets a little bit fuzzier as you go down the spectrum. It doesn't appear to me that there's a requirement that, a borrower doesn't have a line of credit they could draw down or anything like that, but it's a little bit unclear at this point what actual need is. And I think the purpose of this question was to get folks to think twice about whether they actually need these funds and whether they can make the certification in good faith. I will also note that Treasury said, if you think you made this, if you applied and got a loan and now seeing this guidance feel that you can't make the certification in good faith, if you repay the loan in full by May 7th of this year, SBA will essentially not come after you. Will have been deemed by SBA to have made the certification in good faith. So a little bit of a safe harbor for some companies that are maybe on the margins that they did take some proceeds down. So I think it's a fact. Yep, go ahead.
Yeah, I think we need to cut off there. We've run over a little bit. We did have some other questions, but they would require us to open new topics. The person who is assisting us with the program tells us that we can match the questions with the questioner, and we'd be glad to get back to people that ask those questions that we don't have time to answer now. So thanks everyone for participating in our program. I hope you found it useful, and please feel free to get back to us and ask additional questions. We look forward to working with you over the months and the years. Thank you.